apply to the SFO Director.
Charles Chevelle.
Thank you, Mr. Chairman. Mr. Chairman, I want to begin just by thanking my colleague for taking the committee through the history and the context of Clause 57 and the subsequent parts of the bill. I spoke a little earlier in the debate about this particular part of the legislation. I found it puzzling, and I now have some context for the provisions, but I would, notwithstanding the fact that the Minister and the Chair is not the Minister with carriage for the bill, I would be very grateful if he could ask the officials for some advice on whether, particularly in light of what we've heard from the Honourable David Parker, it makes any sense to retain clauses 57 and the clauses that follow relating to declaratory orders. Because clearly what appears to have happened just following the text of the bill is that there was an original proposal for what was called residual warrants. The committee recommended, and I know that the Minister was on the committee, I wasn't, but he and David Parker were. Clearly what happened here is that there was a recommendation from the committee to strike out the provisions relating to residual warrants and a decision to replace those provisions with one relating to declaratory orders. And this was a set of provisions that would have allowed, or would allow if we enact this legislation, law enforcement to go to the High Court or the District Court and ask for an opinion about the legality of any particular type of surveillance. And as David Parker pointed out, as a result of the Hamed decision, and this drafting hasn't changed since Hamed was handed down, and Parliament applied what we might call colloquially a temporary fix last year to this situation that we were alerted to because of Hamed. Notwithstanding Hamed, we've still got provisions around getting these declaratory orders in place, and as David Parker's pointed out, they're virtually redundant except in respect of one type of surveillance, thanks to Hamed. So I think we do need to hear from the Minister and the Chair about whether or not it's desirable to still retain clauses 57 through to 61, because we're really in danger, I think, of enacting provisions that really don't have any meaning as a result of a judicial decision that we've now had some time to consider. I said that it was helpful to have had the history and the context of the legislation explained, because I think it does show that we probably don't need these provisions, and I think if we're taking our responsibilities seriously as a committee of the whole House, we should be looking at the question of whether to retain these provisions. I have some more serious concerns about them, and I did allude to them in my previous remarks. I'm going to just reiterate those concerns for the Minister and the Chair. We don't, as a rule, in common law countries, put the courts in the position of giving opinions. Our system, as the Minister knows, is one where there's a dispute of fact that goes before the courts, and the courts pronounce definitively on the dispute of facts by applying the law to that dispute, and that's the way things are done. In New Zealand, we've never constitutionalised that, but in Australia, for example, the Commonwealth Constitution makes it very clear that that is the judicial role. It would be unconstitutional in Australia to enact this sort of provision where the courts are put in the position of being advisors to the executive. And I still have a major reservation about the propriety of doing this and the wisdom of doing this, independently of the fact that we've now learnt in this debate that the provisions are probably redundant in any event. What happens if an abstract dispute or an abstract request for an opinion goes before the High Court, and the High Court, under these provisions, delivers itself of an opinion? as it would be obliged to do on the face of Mr. Chairman, of the clauses.
Charles Chevelle.
And then the opinion being expressed as advisory only from the court is brought up in a subsequent real case, a real dispute over the legality of a particular type of surveillance in a district court. Now, what sort of position would the district court judge be put in that real-life dispute situation? What sort of discretion would that judge have in any real sense in the face of a High Court advisory opinion on similar hypothetical facts? The reality is the judge would have none, because there would be, thanks to our doctrine of stare decisis, even though this is all expressed to be advisory, the judge would not in reality have any freedom to do anything other than apply the so-called advisory opinion given on a previous occasion in a hypothetical situation by the High Court. I think that's an indication of why we don't generally enact the law in this way, why we don't put the courts in the position of trying to give advice to the executive. We have a Crown Law Office and we have Crown Solicitors. They are perfectly capable, and as the Minister knows, every day they give this sort of advice in practice to the police and to prosecuting authorities. We shouldn't ask the courts to somehow become the advisors of the executive. That violates the notion of the separation of powers, and as I've tried to show, it will result, if these powers are ever used in any extensive way, it will result in embarrassing and uncomfortable situations as far as the courts are concerned. And finally, as the Minister knows, the courts have got enough to do at the moment. We are constantly trying to find ways in this House of easing their burden and their workload rather than adding to it. I just do not understand, particularly given what we've heard about the Hamed decision and the fact that these provisions are now moot anyway, largely, why we would legislate in this way. And I appreciate that it's difficult for the Minister and the Chair because he's having to take carriage of this temporarily, but I think this is important enough, and it's certainly not an attempt to spin the debate out. This is a very serious question, and I wouldn't be taking time on it unless I thought it was well worth consideration of removing these provisions from the Part 3 that we're now debating. And in fact, if there's time in the debate, I think I ought to move formally that the committee do that, because it seems to me, as I say, given what we've heard, that clauses 57 through 61 are not only moot but are actually undesirable.
The Honourable Chester Borrows.
Thank you, Mr. Chairman. And just in response